morning, American Jury and Bulldog Nation. This is a continuing series that I'm doing on the law. And today, we're going to discuss something that I made my career out of, which is personal injury. When we say wrongful death, all wrongful death is a personal injury case that results in a death. But we're going to cover this, and I'm just going to do it without I have no teleprompter, just off the top of my head. I got an outline. It'll help keep me on track a little bit. But this is going to cover any personal injury that you'll have, whether it's a car accident, boat accident, truck accident, premises liability. I'll do a special one on that. But this is like the broad spectrum. I just did medical malpractice, so some of these elements apply there as well. But let's get started. This is something most people don't realize in their everyday life, but it's the truth, and it's something you need to be very conscious of. You really do. All of us have a universal duty to everyone else in every circumstance to act reasonable. Now, you don't have to, but if you don't, and someone gets injured as a result of your conduct, wherever it is and whatever, you could be held liable for a personal injury claim, and if it results in death. I want to start out right now that we're not going to delve in to workers' comp, because workers' comp is a whole other animal. One of the things that I want you to know is with a workers' comp claim, if you're hurt on the job or during the course of your job, you're much more limited. But I'm going to do a separate video about that. All right. A breach of that duty is negligence. It's that simple. You know what? Every Joe American can understand basic tort law. They call it torts in law school, which is hysterical. Torts means injury. It's really simple. We all have a universal duty. If you breach that duty, and the negligence must be the proximate cause of harm. Again, if a pharmacist gives you the wrong medication and you take it, but you're not harmed in any way, shape, or form, you don't have a claim. You have to have a duty. We all have it. A breach of that duty, and it causes harm. When we say proximate cause, it has to be like direct cause. It's not like some far out cause. Now, damages. The damages that you're entitled to, they call them compensatory damages, include your lost income, your mental and physical pain and suffering, past, present, and future. Past from the date of the incident, and future, same thing with the income. Property damage. If your car's hit and it's somebody else's fault, you're entitled to that property damage. Medical bills. You're entitled to have your medical bills paid. Remember, if an insurance company pays your medical bills, you got to pay them back when you recover your claim. We covered that in medical malpractice. Punitive damages. Now, if I go up to somebody, like I go up to Josh here, and I punch him square in the nose and break his nose, that's an intentional assault and battery. Not only will I go to jail, I'll get my probation revoked. Josh will sue me for intentional tort, they call it, an intentional injury, assault and battery, and he can recover punitive damages. Intentional is usually considered malicious. If I went up and punched Josh, that would be considered malicious. Let me tell you something about punitive damages. Punitive damages are to punish. You don't get them in contract cases. You don't get them in simple negligence cases. Punitive damages, you get them in fraud, and you get them in intentional tort. By the way, punitive damages generally aren't covered by insurance and generally are not bankruptable. So they'll haunt you for the rest of your life. All right. I'm going to talk about insurance here because most people, when they're injured, it involves an automobile accident, usually. Relative to insurance, if you can afford it, or you have a new car with a lien on it, you're going to have property coverage, what we call collision, full coverage. So if no matter whose fault it is, you have insurance on that. Also, if you operate a business, you generally want to have insurance on your business. We have homeowners in case somebody gets hurt at your house, so forth and so on. Liability insurance. That's what you got to have by law to drive around in your car. What that means is that it won't cover you, but if you cause somebody an injury, you have liability insurance to cover that. There are limits to that. In Kentucky, unless it's changed, it used to be $25,000 in liability. Ohio was $12,500. Now, let's say the person who hit you doesn't have insurance. They are what's called an uninsured driver. You can purchase at your option what's called uninsured insurance. So if somebody hits you and they don't have insurance, this on your insurance will cover you. Then there's something that's called underinsurance. Underinsurance is to insure you when the guy that hits you and causes the accident doesn't have enough to cover your claim. Let's say you're in an accident and both your legs are broken and you got to go through 6 months of physical therapy. Well, if they only have $25,000 of liability insurance, you're going to need your underinsurance. If you want to insurance up, folks, you want to make sure you get uninsured and underinsurance on your insurance policy. I also want to point this out. If you've got healthcare insurance, that can cover your medical bills as well. Kentucky and Ohio and a lot of states have what's called NoFault. And what NoFault is supposed to say, hey, before we find out whose fault the accident is, you got a certain amount of money to pay for medical bills, lost income, and everything like that. To be honest with you, I think it's all been kind of goofy. But regardless, in Kentucky, that's $10,000. If you've been injured in a little whiplash case, you might have had this happen to you. You go to a chiropractor, in some miraculous reason, after you get treated $10,000 by a chiropractor, they tell you that they're finished treating you. You know why? Because they just used up your $10,000 no-fault coverage. All right. Some people have an umbrella policy that covers a little bit of everything. Premises. I'm going to do a separate video about this, but if you're hurt, this is a myth, just so you know. You are not automatically responsible for somebody who gets hurt on your property. That's a myth. You're only responsible if somebody gets hurt on your property if you do something negligent or you have some type of condition you didn't warn them about that's going to cause some injury and it happens. All right, you have 1 year to bring a claim for what's called loss of a consortium, loss of love, affection, and services if you're married. That's a real thing, folks. Trust me. 2 year, if you're an adult, you're in an automobile accident, you generally have 2 years to bring a claim from the last no-fault payment. It gets really technical. Here's the bottom line, folks. 2 years for a car wreck. But don't think like that. Just like I said in the medical malpractice, always think a year. Always think a year. And any type of personal injury claim that's not a car accident, you got 1 year to bring it. And by the way, it's not the year, it's not the anniversary of the, it's the day before, just so you know. So 1 year, all other. You have 1 day before your 19th birthday to bring a personal injury claim for a minor. Now, you don't want to wait that long because of facts going away and everything else. Speaking of facts, like in everything, the whole business of law, litigation, personal injury, medical malpractice, civil rights, involves the application of law to a set of facts. So all those different myriad of facts that can happen to you getting injured all matter. Where, when, why, how, who, what happened, who did what to whom, everything. Red light. Did they run the red light? Not run the red light? Were they intoxicated? Were they high? Did they make the turn wrong? Were they distracted? Who ran the red light? Who had the right of way? Whatever it is, gets complicated. All right. Other parties besides the driver. This is really important. You always want to think, especially in a really serious case, alcohol. This is a wild case I had. I had a case where a guy suffered a permanent brain injury on his motorcycle. He was hit by this little girl on a pickup truck that was underage. You can't make this up. Found out that this little girl drank alcohol at a house served by an adult, bought alcohol from a convenience store, drank alcohol at a restaurant, then went to a bar and drank alcohol at a bar. She got alcohol from 4 places. Just all 4 places. I got money from all 4 of those places for this guy, and he needed it. Defective product, a defect in a product. Brakes go out. There's something wrong with the brakes. We're sitting here right now, and something breaks off on that light, hits me in the head, kills me. Why did that fall on my head? Was it a defect? I'm going to do a whole separate video on products liability. The road. Did the paver do something relative to the road that caused the accident? The government. Did the government do something wrong? Manufacturers. Did they manufacture it? All relevant. A lot of tort law involves police reports, especially when you're dealing with an automobile accident. The police report is important because it outlines the first account of what happened in writing. However, I want you to know that just because a police report says X, Y, Z doesn't make it so. Police officers make mistakes. But the police report makes a difference. The lawyer, I want you to know that lawyers that handle these cases, they're a dime a dozen. Almost every lawyer handles a quote-unquote personal injury case. You know why? Because they're not all that complicated. And they're not all that expensive to pursue, normally. And they generally pay 1/3. They get paid 1/3 for their attorney fee. I tell you right now, though, you need a lawyer that gives a damn about you. Here is the biggest sin that I see from plaintiffs' personal injury lawyers. They do the wham, bam, thank you, ma'am, grab the easy money and say they're done, instead of really digging in and seeing where else maybe they can find a pot of money for you. Let me see, like that guy that advertises before Bengals games. Jeez, wham, bam, thank you, ma'am. I was famous for always digging. All right, drive. That should be driver. That's just what the edit is. The driver. Who's the driver is somebody, who's generally responsible. And you generally are suing the driver's insurance company. The passenger, if you are a passenger in a vehicle and that driver does something negligent, you can bring a claim, if you're the passenger, against the driver. Family members forget about this. If you're the brother of the sister who causes the accident, you can sue your sister's insurance company, make a claim. By the way, here's the other thing. People always say, well, I'm worried about my insurance rates going up. I can tell you right now, recovering a personal injury claim will more than offset insurance issues. So even if it's your best friend, if you're injured, your best buddy ought to say, yeah, go ahead, make a claim against my insurance company. All right, contributory negligence. That's when the person who's pursuing the claim did something that helped cause the accident. We generally don't have that anymore. We're getting in Kentucky and Ohio, we have comparative fault, and we'll talk about that in a second. Seatbelt. You have to have a seatbelt on. However, if you're injured and you didn't have your seatbelt on, that might reduce the amount of money you get, but that doesn't make your claim worth nothing. Texting, that's a big thing these days. If you have a big claim and you want to dig, checking somebody's phone records, you can issue subpoenas, find out who they were, get their texting records, and you find out they're texting at the time of the accident. That's a big deal. Now, comparative fault. Kentucky and Ohio has what's called comparative fault, but they're different. Let me explain this. In Kentucky, they have what's called pure comparative fault. So let's say Josh is driving a car and I'm driving a car, and he runs a red light and I turn left the wrong way. A jury can say, Josh is 70% at fault, and I'm 30% at fault. What does that mean? That means Josh is only going to recover 30% of his injuries, and I'll recover 70% of my injuries because he's 70% at fault. Let me tell you what Ohio does. Ohio has 50% threshold. What does that mean? If you are more than 50% at fault, you don't get a nickel. So in Kentucky, it's a more plaintiffs-friendly state. Imagine that. Ohio, you got a Republican legislature and a Republican Supreme Court. Good luck with that. Social media, folks, if you're telling the world that you're hurt, you're dying, you're suffering, you're in pain, I'm in pain, and you're posting pictures of your ski trip in Idaho, trust me, insurance companies check out everything. And their Nazi lawyers check out everything. Just letting you know. They have spies that they will videotape. They'll send people to track you and videotape you. I once represented a guy that said his back was hurting him. They got videotape of the guy loading up a truckload of furniture by himself. I lost. Medical records. Medical records are really critical. Medical records are going to put down how you were hurt, how bad your injury. Medical bills will reflect how serious your injuries are. Your doctors will be called upon to maybe write a report to help it get it settled or testify in court. If you go to trial, you have to have doctors testify in court about your injuries. That's the way it goes. Pre-existing conditions. If you already have a screwed up back and you're in a little whiplash case, they factor that in. That happens a lot. I had this case once. This is the case. This is hysterical. Our office had a case, and this is the one where I got fined $10 or $10,000 for the unauthorized practice of law in Ohio. I was not handling the case. I was retired. Lawyers are handling the case, and this guy comes to me because he's a fan. He says he hurt his knee real bad, blah, blah, blah. And he's got this great case, and he wanted to settle for that $100,000 real quick. Wham, bam, thank you, ma'am. Well, he lied. The guy lied. He had a major knee problem before the damn accident. So when we got out of the case, they filed a complaint against me. That's how I got fined. You believe that? It's hysterical. Like 3 or 4 years later, the case still hadn't been settled. That guy that does the football commercials had it. But, you got a pre-existing condition, and it's in your medical record. Now, if you never went to the doctor for it, they won't find out. By the way, just like I did in civil procedure video and medical malpractice, there is a discovery process if you bring a lawsuit in this, and they get all your medical records, your school records, your work records. They get all your records. You know what I call it? They stick a microscope up your colon. They do. So anyway, well, this has been a broad overview of personal injury, wrongful death. By the way, if you die as a result of an accident, there has to be an estate set up in probate, and the executor of your estate or executors of your estate are the ones that will pursue the claim on your behalf. Depending on what your will says, your heirs will recover the money. So that's the only difference in a wrongful death case is you're going to set up a probate case. I'm going to do lots more of these videos as we go. This is Eric Deters, the law, ericdeters.com, 859-250-2527. Remember, this isn't legal advice. It's strictly educational. It's 100% free. Text me and email me if you're ever injured or, somebody in your family or close relative passes away. Be sad and tragic. But if you want to pursue a claim, let me know and I'll hook you up with the right lawyer in my world. This is the Bulldog. Every dog has her day. You have a great day.